So what are permitted development rights? So there are national grant of planning permission for certain building works and change of uses, and they could be carried out without having to make a planning application. So it kind of takes away the control of the council. So the government have put together legislation that says, here's a bunch of things that you can do without needing to go through the whole planning process. And this was brought in to speed up the planning process. I'm not necessarily sure it's actually done that on the basis of how complicated it is. But sorry, I need to admit someone in. But yeah, so that's why they brought them in, to speed up the planning process. And it, as I say, it takes away control from the council, as it's a government-led legislation. So what are permitted development rights? So what you're able to do, there's a general permitted development order, which is, we're going to call it the GPDO as I continue through this presentation, just because it's a lot quicker. And that is, I say, legislation is available online with all the information of what you can do under permitted development rights and all the conditions that fall under those permitted development rights. And it's like some of them are like a checklist. So you'd have to tick off, you can't do certain things. I say it's one of these things I couldn't even begin to go into it because it's just so extensive on what they offer. So there are some exceptions where you cannot do permitted development rights, and they are conservation areas, areas of outstanding national beauty, national parks, heritage sites, listed buildings, and things like that. So they're all exempted. So if any of your property or the site falls within an area that falls within those categories, permitted development rights, you're not able to do those. We also have Article 4 directions, which I'm going to talk about later on, because again, that could be another whole presentation separately. An Article 4 direction is something that the local planning authority can bring in to remove permitted development rights from a certain area. So, as I say, permitted development rights cover a number of developments, or like in a range. They cover a lot of things. But what I would say, so prior approval is part of permitted development rights. So certain permitted development rights, you'll be able to just go ahead as long as you tick the boxes that they've written out in the legislation. You'll be able to go ahead and do the works without getting planning permission. Prior approval is part of permitted development rights. So it's for the larger schemes, the more controversial schemes. And it essentially says, because we know these are more controversial, we're going to make, you have to submit prior approval application to the council. So although an application is going to the council and works cannot take place until the council have made a decision on that application, the council are restricted on what they're able to make and what the decision they're able to make, what they're able to consider. So yeah, I just want to make that very clear that with prior approval, there is a set criteria within the GPDO that the council can look at. So it's not like a full planning application, because with a full planning application, they get to assess and balance the planning balance and like weigh up all the pros and cons of the development and come to a decision. That's not able to happen with a prior approval application. It is a case of, here's a list of, say, 4 things you have to consider, and the council can only consider those things when making the decision. So from what I understand, it was the building upwards PD rights that was the concern for yourselves. So under the GPDO, these are the statutory requirements that the council can consider when assessing that application. So although it looks like a lot, it does significantly reduce the council's power. They don't have as much say over it as they would say it came in as a planning application. So I'll talk about later on about what you as a residents can do when it comes to these types of applications. So yeah, that was just kind of to summarize about the prior approval process, that it's essentially a light touch process because the principle of the development is acceptable. Under permitted development rights, it is just a case of the council checking over, as say, a few of the statutory requirements that the government have allowed them to check over. So in this slide, I've just set out the process, and I can show you a slide later on that shows you the planning process, and you'll see the difference in the different stages in this. So you'll see there is a consultation period, and that, again, that doesn't happen on all permitted development rights, but it will happen on all permitted development rights that require prior approval. So again, the larger schemes, the more contentious schemes that prior approval is required for, you will be able to get to consult on that. But as I'll go on to send a few slides, it is a case of the council are only able to consider your comments that are relevant to what they're able to assess the application on. And yeah, it is a case of the planning officer is able to assess as that criteria that they're allowed to, and they just have to check that it's compliant with the GPDO. And if it is, prior approval is given. And if it's not acceptable, but a condition can overcome why it's unacceptable, prior approval still has to be given. Whereas if a condition cannot overcome why it's not acceptable, that's when it's then refused. But yeah, I'll go into that later. So how does this apply to Gaywood Estate? So yeah, so it's the upward extensions that I think that is your main concern. And as I say, they do fall under permitted development rights. That came in August 2020. Because the government are adding, to be honest, they added a lot more in the last 2 years onto permitted development rights. And I'd say that's, again, their justification for that is to speed up the planning process and to get more houses into the UK. So yeah, it's a new one that came in August 2020. So there's still a lot of things to be finalized with it, as in the legislation is finalized, but how that legislation is interpreted is still ongoing a bit with a lot of applications. Yep, and I say this particular upward extensions can apply to commercial, residential, and mixed use buildings. So this is probably the part you're most interested in, is resident involvement. So as I said, permitted development rights generally take more control away from the council, which then takes control away from residents' ability to actually have as much say as they want to in that development. Because I say the council can't consider everything that you want them to consider because they're not able to under the legislation. So when I said about you do get consulted on these applications, and I've put the 4 areas that you're able to consult on. As I say, you can put as many things as you want into an objection and do a comment letter, but these are the only 4 things that the council will look at. So my recommendation would be to focus on these 4 areas. And I say it's a case of the consultation goes out just to make sure that the council don't miss anything. So as I say, if you're able to identify a certain level of overlooking that the council maybe haven't picked up on, that they'll take that from your comments and add that in to their report. But I will say that just because, and this goes for any application, permitted development rights, prior approval, or full applications, just because you object or just because you put in a comment to say, why you don't want the development to go through, it doesn't mean it's not going to be approved. It's always worthwhile putting the comments in, because I say it can help the council to see certain things that maybe they hadn't picked up on before. But I always find a lot of people expect then the application to be refused based on their comments, and that's not how it works. So as I said, following on from that, as in just because the council aren't able to have as much control over it as possible, and you can't necessarily object and have it refused. I have kind of put in a slide on how to mitigate the impact of permitted development rights, because I do think as a resident association, I think that's the best thing for you to do, and I think that's the way that you're going to be able to go forward in the most proactive way. So as I said, it's only the statutory requirements that the council can consider. They can't fully consider a neighbourhood plan or development plan as they would with a full planning application. But you can, so I'm not sure if you have a neighbourhood plan for your area, but yeah, if you do have a neighbourhood plan, or if you don't, that's something that you might want to put together on the basis that, say, within your neighbourhood plan, you have noise levels cannot go above a certain level. That can then be considered in the council's response, because although they're not fully considering the plan, it's within that area, and they can add that into the statutory requirements to say, well, this is how we as a council in this area look at this certain part. So as I say, it doesn't hold as much weight as it would in a full application, but they do hold some weight, and they might help, as I say, to reduce the impacts rather than completely remove the development happening. I would say the next thing to do would be to encourage the council to add conditions. So once if the prior approval is coming in, it's, as I say, a lot of developers will be on the ball. They'll know what the statutory requirements are, so they'll have looked at those. So it's likely that the application will go forward for approval. The next part of your role as residents could be to encourage the council to add conditions to that application, because that gives you back control. So again, that would be the likes of when you do your consultation to say, well, we accept it's going to be approved, but we would like to have it, built out this way, or we would like, to have these kind of restrictions put on it, or we would like, just to have more of a say. And I say, as long as it is conditionable and enforceable, the council, they can add that on. So I've seen it, there's like construction management plans and things like that with certain hours that people can work within. And again, that's something that can be conditioned. The likes of screening, if you think overlooking or privacy is going to be impacted, that's again something that they can put a condition on an application. So although the development's going to go ahead, it just reduces the impact of that development on residents as a whole. And lastly, as I said, I mentioned the Article 4 directions before, and these essentially allow the council to completely remove a certain permitted development right within that area, which I know sounds ideal and exactly what you probably want to do. I will say it is very hard to do, and it's going to become more hard in the next few weeks, because the government are actually bringing in, well, there's talk of the government bringing in another addition to the law to say, just to make it more difficult for Article 4 directions to come forward. So I've put it in there to let you know that Article 4 directions exist. But as I say, I don't think that's necessarily the best route for you to go down, on the basis that it's very difficult for the council to do. And I can't imagine they'll be able to get it through, because ultimately it is the Secretary of State that makes that decision. So, they've put these forwards. They're very unlikely to allow a council to remove them just for the sake of it. There has to be a number of really good reasons as to why they would do that.